Good morning.
Good morning.
Welcome to our panel that will address the role of historically Black law schools. My name is Felecia, and I serve as Dean of the University of North Texas at Dallas College of Law, located in lovely downtown Dallas. We are a new law school, having graduated our first class in 2017. Key to our mission is diversifying the legal profession. We are a minority law school with just over 50% students of color. The majority of those students are Hispanic. Prior to becoming Dean of the UNT Dallas College of Law, I was Dean of the Florida Agricultural and Mechanical University College of Law, affectionately known as FAMU. FAMU is a historically Black college or university, and I discovered in my role as Dean there that although HBCUs have been part of my life for my entire life, my parents are both alums of an HBCU, there were many who did not even know of the existence of these historical and critical schools. 6 of the HBCUs have law schools. And I'm honored today to moderate this panel composed of the deans of those law schools. All have very impressive backgrounds that are available to you in the program. So I'm not going to review all of that. I'm going to start by asking each of them, after I give them their names and the schools that they are deans of, to just introduce themselves to you in a little more detail and also tell you about their institution. We have Joan Bullock, who is Dean of Texas Southern University, Thurgood Marshall School in Houston, Texas. We have Danielle Holley-Walker, Dean and Professor of Law at Howard University School of Law, Washington, D.C. Renée McDonald Hutchins, Dean and Joseph L. Rao, Jr., Chair of Public Interest Law at the University of the District of Columbia, David A. Clarke School of Law in D.C. We have Deidré A. Keller, Dean of the historic FAMU College of Law in Orlando, Florida. Go Rattlers, I have to say that. Browne C. Lewis, Dean of North Carolina Central University School of Law in Durham, North Carolina, and John Pierre, Chancellor, Southern University Law Center in Baton Rouge, Louisiana. And I would ask Dean Bullock to go ahead and introduce yourself and tell us a little bit about your school.
Thank you, Dean Epps. Good morning. I'm Joan Bullock, Dean of Thurgood Marshall School of Law at Texas Southern University. This is my second year at Thurgood Law, and I am humbled by the opportunity to serve as Dean of a school that has made such an impact in increasing African-American representation to the Texas bar. I want to thank the University of Houston Law School and the SMU Dedman School of Law in hosting this conference, in particular, the University of Houston. Texas Southern University and the University of Houston shared a common beginning in that both had their origin with the City of Houston school system in 1927. The University of Houston began as the Houston Junior College, and Texas Southern started as the Houston Colored Junior College. In 1934, both schools became 4-year institutions, with the Houston Junior College becoming the University of Houston and Houston Colored Junior College becoming the Houston College for Negroes. In 1946, Heman Sweat, a Black man, applied to attend the all-white University of Texas Law School in Austin, Texas. This was the state's only law school, and he was denied admittance. With the assistance of the NAACP, Sweat filed suit in May of 1946 against the University of Texas president, Theophilus Painter, and other university administrators. Painter had stated that Heman Sweat had the credentials to attend the University of Texas and was denied admittance because he was a Negro. While this matter was being litigated in the state court, Texas lawmakers busied themselves with creating a school for Blacks that within a span of 6 months would meet the requirements of the then legal separate but equal doctrine as upheld by the United States Supreme Court in the 1896 case of Plessy versus Ferguson. The Texas legislature in 1947 approved the purchase of the Houston College for Negroes for $2 million to be the site for a new law school for Negroes. With the renaming as the Texas State University for Negroes, and with money pouring in from the state, the Negro University began to be transformed into an institution that would pass the separate but equal test of being deemed substantially equal when compared to the University of Texas. Texas State University for Negroes opened its doors in September 1947. It had 2,300 students, 2 schools, the law school and the pharmacy school, 1 division, the vocational division, and 1 college, the College of Arts and Sciences. Since the only state law school was located in Austin, Texas, the Texas State University for Negroes temporarily established a law school in Austin near the University of Texas in the fall of 1947, while a permanent facility was built in Houston. The makeshift law school was located in the basement of a building not far from the University of Texas to permit the University of Texas law professors to run over and teach the Black students at the separate location. 3 Black students, 2 males and 1 female, began their studies in the basement. The female student withdrew after a few weeks. Heman Sweat was not one of those students. He continued his lawsuit as part of the strategy of the NAACP and Thurgood Marshall to dismantle the separate but equal doctrine. In the fall of 1948, the construction of a facility for the Texas State University for Negroes Law School was completed in Houston, and one of the male students completed his law degree in Houston. Sweat's case was heard before the United States Supreme Court, and a unanimous decision was rendered in June 1950. The court found that the legal education offered to Mr. Sweat by the Texas State University for Negroes was not substantially equal to that which he would have received if admitted to the University of Texas. The court ordered that Mr. Sweat be admitted to the University of Texas Law School. Mr. Sweat and 5 other Black students enrolled at the University of Texas Law School in January 1950. Mr. Sweat, unfortunately, did not graduate from the law school because of health challenges he encountered, partly as a result of the arduous fight he made in seeking equality and equal treatment under the law. After the Supreme Court's ruling in favor of Mr. Sweat, the lawmakers greatly reduced their efforts to create an institution for Blacks that would be considered substantially equal to the University of Texas. That following year, the budget for Texas State University for Negroes was severely cut. A bright spot from the Supreme Court's ruling was that the strategic goal of Thurgood Marshall and the NAACP in litigating this case was not getting Heman Sweat admitted into the University of Texas Law School, but to dismantle the separate but equal doctrine. Sweat versus Painter was one of several strategic nails hammered by the NAACP into this doctrine's coffin, and it paved the way for Browne versus Board of Education, which was decided in May 1954. In that case, the court ruled that segregation based upon race in public schools was unconstitutional, even if the segregated institutions were otherwise considered equal. Getting back to Texas State University for Negroes, on June 1st, 1951, it was renamed Texas Southern University, and in 1978, the law school was honored by Justice Thurgood Marshall, allowing the law school to be named after him. Justice Marshall was a fervent adversary of Jim Crow laws and initially did not want to have his name associated with a Jim Crow law school. We are thankful, however, that he relented regarding his objections, and the Thurgood Marshall School of Law has been just as fervent an advocate against Jim Crow laws and other laws that serve to disenfranchise, marginalize, and silence others. It has done so by having an outsized impact on the number of Black attorneys who are members of the Texas Bar in comparison to the other Texas law schools. Thurgood Law has produced 13% of the active minority attorneys in the state of Texas, and Thurgood Law has produced the most African-American attorneys in the state of Texas in comparison with any other law school. As we look at society today and at current events, we can see that there's been a lot of change for the good of all. We can also see that we have still a long way to go, and that long way is not all downhill. The need for Black lawyers is just as important today as it was when unjust laws were on the books and enforced. Those laws may not be on the books, but the values held by those who put those laws in the books are values still shared by many, and that many in power. Black lawyers are needed to advocate and speak for those who have limited voices, those who are vulnerable, and those who are without recourse and without resources. And Thurgood Marshall School of Law at Texas Southern University is up for the challenge.
Thank you, Dean Bullock. Dean Holley-Walker.
Thank you so much for having us today. Thank you, Dean Epps, for being wonderful moderator for this panel. I want to thank SMU, Dedman School of Law, and the University of Houston Law Center, and a special thanks to two of my favorite deans, Dean Baines and also Dean Collins, for having such a wonderful idea to put this wonderful symposium together. I came to Howard University School of Law as the dean in 2014 and had the honor of leading this historic law school. I also have a connection to another HBCU law school. When I was 4 years old, my family moved to Houston, Texas, and my father became a faculty member at Thurgood Marshall School of Law in Houston, Texas. So I grew up as a faculty kid at Thurgood Marshall School of Law. So Thurgood Marshall School of Law is incredibly close to my heart and is still my family of the Tiger Law family at Thurgood Marshall School of Law. So Howard University School of Law, Howard University was founded in 1867, right after the Civil War, by the head of the Freedmen's Bureau, General O.O. Howard. Howard University School of Law, the law department started in 1869 with the idea that, of course, these would be African-American lawyers who would serve their communities. And at the time, that really meant a lot about, you know, kind of the basic needs of the African-American community in terms of drafting wills and working with families on family law needs, et cetera. One of the unique facets of Howard University's law school from the very beginning in 1869 is that we had women as law students, and including white women who were law students at Howard who could not get admittance to other law schools who were not admitting women. Two of the white women who were students very early on at the law school went on to found another law school, American University's law school was founded by two Howard Law graduates. Probably the most famous period in the Howard Law history is the period of 1929 to 1935. So Charles Hamilton Houston came to Howard Law as the dean in 1929. He was actually, his actual title was vice dean, but he functioned as the dean of the law school. And in that period, he had the idea that Howard Law would, number one, become ABA accredited. So they worked very hard to close their night school, to close the part-time program, and Howard Law became the first African-American or HBCU law school that was ABA accredited. Also in this period, Dean Houston believed that Howard would be the central laboratory for the end of Jim Crow segregation. And so he required students, faculty, and staff to work together on the civil rights cases of the time and the strategy that would eventually end Jim Crow, some of which you just heard about from Dean Bullock. So in that period, they would moot cases at Howard's law school and walk together to the Supreme Court as people like Dean Houston argued those cases in front of the Supreme Court. And the strategy at the time, which was the idea that eventually they would argue that separate was inherently unequal, was really formed in that civil rights laboratory of Howard University School of Law. One of the principal architects of that strategy was a 1944 graduate of the law school named Pauli Murray, who in her senior thesis, in her 3L thesis at the law school, argued that the only way to truly dismantle Jim Crow segregation was to argue that under the 14th Amendment Equal Protection Clause, that you could never have separate facilities that were equal. And a lot of that strategy that developed in that civil rights laboratory of the law school then became the backbone of what eventually was Browne versus Board of Education in 1954. So today at Howard's Law School, we carry on that legacy. Our mission is to train lawyer leaders who will lead the fight for racial justice. So we are a very mission-based law school. About 90% of our students are students of African descent. So we graduate approximately 140 African-American lawyers every year, which generally makes us the top producer for African-American lawyers each year. Our other strong mission is diversity in the legal profession. We believe that part of our central duty is producing Black lawyers for the profession when we know that Black lawyers are only about 5% of the profession. We are especially focused on areas in which Black lawyers are even less in population than they are in general in the profession. So areas like intellectual property, alternative dispute resolution, corporate law, and environmental justice are several of our focuses. And we are very proud of obviously our outstanding alumni, including, as mentioned, Thurgood Marshall, who's 1933 graduate and the first African-American Supreme Court Justice. Currently, people like the Attorney General of New York, Letitia James, Senate candidate Mike Espy, and many federal judges like Emmett Sullivan and LaShawn D'Arcy Hall and many others. So I'm really excited about being here with you this afternoon and look forward to being in conversation with the HBCU law deans. This is an incredible group of law deans who really have a strong vision for diversity in the profession, and I'm honored to be with them today. Thank you.
Thank you, Dean Holley-Walker, and now Dean Renée Hutchins.
Good afternoon, everybody. Thank you, Dean Epps. Like others have said before me, I want to thank SMU and the University of Houston and Dean Baines and Dean Collins for today's conference and this panel in particular. I am absolutely delighted to be here. As Dean Holley-Walker said, this is a tremendous group of HBCU deans, and I am honored to serve among them. I am the Dean of UDC Law School, the University of the District of Columbia's David A. Clarke School of Law, and I am sure some of you are saying, hey, what? UDC Law is an HBCU? It in fact is. So unlike the other 5 HBCU law schools, UDC Law did not begin as an HBCU. We became an HBCU. We became an HBCU in 1994 when we merged with the University of the District of Columbia. We had two previous predecessor institutions. We started as Antioch Law, and then when Antioch closed, became the District of Columbia School of Law, and then merged with UDC, and at that point became UDC Law. And while we do not have the history of starting as an HBCU, we do have a profound commitment to that identity currently. So we are invested. We have a dual mission. It's a mission that is actually enshrined in statute. We have a dual mission to both diversify the profession and advance the mission of social justice. So we are profoundly committed to creating what we like to call social justice warriors at the law school. Our motto is practice law, promote justice, change lives. We believe firmly that solid clinical legal education is essential to producing qualified lawyers. And so we have a very solid clinical program. I think it's currently ranked number 8 in the country. And we require all students in our day program to take 2 clinics before graduation. And so we are profoundly committed to providing students with the practical skills and knowledge in addition to the theory so that they can go out and change the world, right? Be the change that they want to see in the world. We also believe profoundly that coupled with access is affordability, that if students graduate with crushing law school debt, they will not be able to move out into the world and take a range of different positions, that crushing law school debt limits options, limits career options upon graduation. And so another part of our mission is affordability. So it is very important to us that we keep our tuition at a price point that is at this point the lowest in the district. At one point was the lowest in the nation. I'm not sure that we are still the lowest in the nation, but if we are not, we are among the lowest in the nation because we want our graduates to have a high quality legal education, but to be able to then move past law school and go out into any, one of a number of a range of professions where they can change the world. So access, affordability, and advocacy are the things that we are committed to. Like Dean Epps and Dean Holley-Walker said, HBCUs run deep in my blood. I am a Spelman graduate. I am married to a Winston-Salem and Howard Law graduate. Have to give Dean Holley-Walker a shout. My parents are Fisk graduates, Meharry graduates, Wiley College graduates, Morris College graduates. We have got HBCUs in my family for years and years and generations and generations. And so the work that I do at UDC Law to keep this HBCU strong, this HBCU law school strong is in my blood. I think it is so important, as has been previously said, the HBCU law schools graduate a disproportionate number of Black and Brown lawyers. And so I think it is critically important that we do everything we can to keep these institutions strong, and looking forward to the conversation today to talk about why that's so critical.
Thank you, Dean Hutchins. And now Dean Keller.
Hello, everyone. I'm Deidré Keller, and I have the honor of serving the Florida A&M University College of Law as its dean. I just started in this role on July 1st, and like my co-panelists, I'd like to thank the SMU Dedman School of Law and University of Houston for convening this fantastic conference and this panel. And of course, Dean Baines and Dean Collins. And I would be remiss if I didn't thank Dean Epps, who is recognizing her Rattler history there. So I appreciate that. The history of FAMU law is it's a complicated one. Like some of the other panelists have mentioned, we began as a result of segregation. So I'm going to talk a little bit about kind of the prehistory and then bring you up to today. So the first Black lawyer in the United States was admitted to practice in 1844 in Maine. In 1938, in a case called Missouri Ex Rel Gaines versus Canada, the Supreme Court of the United States held that states could not export their law students. They had to, if they had a state law school, either desegregate that school or provide separate but equal facilities. That was in 1938. In 1949, Virgil Hawkins would test that case here in Florida with 4 others who applied to the University of Florida and were denied based on their race. That challenge went up to the Supreme Court, and Florida ultimately decided to open a law college at Florida A&M University. Florida A&M University had been in existence since 1887. So in 1951, the College of Law at Florida A&M University, at that time located in Tallahassee on FAMU's main campus, welcomed its first class of students. Incidentally, just a couple of months before that, the Florida legislature voted to undo its diploma privilege. So until 1951 in Florida, if you attended law school in Florida, you did not have to take the bar exam to be admitted to practice in Florida. Well, just 52 days before Florida A&M University College of Law welcomed its first class, the Florida legislature decided to reverse that course. In 1954, the college graduated its first class. And then in 1965, the Florida legislature voted to close the FAMU College of Law. That vote was really in protest of having to integrate schools under Browne versus the Board of Education. So the legislature pulled the funding for FAMU College of Law and decided to open a law school in Tallahassee at Florida State. In 1966, the Board of Regents, the state accrediting body, forbade FAMU from seating an incoming class. So in 1968, the college graduated what might have been its last class, and in fact was its last class for more than 35 years. In that period, the university never gave up on getting its law school back. But it would take until 2000 for the legislature here in Florida to reopen the law college. And so then in 2002, the college welcomed its first incoming class since 1965. And then in 2005, the college graduated its first class since 1968. Over the course of its history, the college has been integral in diversifying the profession here in Florida. Prior to the start of Florida A&M College of Law, the vast majority of Black lawyers in Florida had been educated at Howard University. And so that is, in a nutshell, the story of Florida A&M University College of Law. Today, we are proud to be and lauded as one of the most diverse law schools in the country. And our mission is to serve as a beacon of hope and catalyst for change by providing access to excellent educational training and opportunities to generations of students seeking to serve the needs of traditionally underserved people and communities, locally, nationally, and internationally. Thank you.
Okay, Dean Keller, I was saying that along with you. I still remember that mission. Anyway, moving on. Next to Dean Lewis.
Good morning, everyone. I'd like to thank University of Houston, where I graduated. I received my LLM from University of Houston and also SMU. I'm a proud graduate of Grambling State University. Go Tigers, not after, no. And so I'm really excited to be here today, and I think this is going to be a wonderful program. I'm the Dean at North Carolina Central University School of Law. And like most of the prior comments, our law school was created to foster segregation. After the Gaines case, when the Supreme Court said, like Dean Keller said, you had to integrate, you had to make sure you had a law school to provide education for African Americans. At that time in North Carolina, Shaw University law school had closed in 1914. So there was no law school in the state to educate African Americans. As a consequence, North Carolina Central Negro College of Law was created in 1939. But because of delays in recruitment and objections of some parties, the law school did not officially open and start enrolling students until 1940. So we are centered, and we see our motto is truth and justice. And so what we try to do, because we're seated in an urban area, we're right next to the biggest housing project in the state of North Carolina. We're also the only precinct in our area, because about 7 years ago, the city decided to eliminate most voting precincts. And so what happens is that in order to make sure that the people in the community had a place to vote during the elections, we became a voting precinct. So we've been undergoing early voting, but it gives our students opportunity to serve as poll watchers and to watch the election process unfold. We also believe that the digital divide is critically important to overcome because of the impact that technology is having on everybody's life. So we've done a lot in the area of technology because of our location in the Research Triangle, and also because of the grants and things we've gotten. We have a patent law clinic, and I'm going to talk later about our virtual justice project, which we've been using to try to make sure that we can go to our motto, truth and service. We have a robust clinical program, and we have a variety of clinics. Our newest clinic is our Veterans Law Clinic that we are reinvigorating. That was closed about 2 years ago, but we got a grant from the state to offer it up. And what we do in that clinic is basically try to help Black and Brown servicemen who were dishonorably discharged because of minor things that we think was racially motivated, because being discharged dishonorably doesn't afford you the right to get the benefits to which you're entitled. So we're working on that. We're the Legal Eagles, and we like to say that we soar above adversity. We take storms, and unlike other birds, we don't go away from the storm. We use the power of the storm to rise even higher. And so we've been educating, like I say, Legal Eagles for about 80 years, and we hope to continue for 80 plus more. Thank you for being here, and thank you for having us.
Thank you, Dean Lewis and Chancellor Pierre.
Good morning. What a pleasure to be here. First of all, like all of my other colleagues, I want to thank the Southern Methodist University School of Law, Dedman School of Law, which I'm a graduate of, SMU's Dedman School of Law, and the University of Houston Law School, Dean Baines, Dean Collins. This is a great idea, and all the other deans in Texas who are part of this, and all the sponsors. First of all, I really am proud to say that I am the Chancellor of the Southern University Law Center. The connections, I will try to bring all of them together because we are really an integral part of all of this. So Plessy versus Ferguson is a Louisiana case. 1896, it was decided in 1896. The governor at that time was a governor named Foster. His grandson graduated from the Southern University Law Center over 100 years later. Heman Sweat, that case was going on, started in 1946. There was another case that Thurgood Marshall was working on involving Charles Hatfield, who sued the Louisiana State University School of Law to gain admission in 1946, on October 10th, 1946. As a result, that case was settled, and Southern University Law School began on September 1, 1947. We were part of the Southern University and A&M College, which began in 1880 and became a land grant institution under the 1890 Land Grant Act, Morrill Act, in 1890. The connections actually to Howard is that Marshall, of course, was a Howard graduate, and so was A.P. Turow and Louis Berry, who were the two other lawyers on that case. They were all Howard graduates, and they all went to school with Thurgood Marshall. The other two were practicing in Louisiana. And so we see the connection, and we, like Central, Florida A&M, and Texas Southern, are what we call, I refer to as Gaines Law Schools. We were all brought about because of the decision in the Gaines decision in 1938, Missouri versus Gaines. We were only allocated $40,000 to begin our law school when, at the end of the Gaines case, there was a law school established in Missouri at Lincoln University with $200,000. So it was never intended that the Southern University Law School was ever going to survive as an institution. But we began in that fall of 1947 with 13 law students. Eventually, 6 of them graduated from law school in 1950. And those 6, as well as others, went on to dismantle legal segregation in the state of Louisiana and in other places. So they carried on the mission of Thurgood Marshall and all of those others, other luminaries who were part of that. We are now one of the most diverse law schools in the country, just like all of the other HBCU law schools. We have over 800 law students. So I believe, if I'm not mistaken, we're the largest HBCU law school in the country. We have a lot of clinics. So we are like Central with a lot of clinics and all the other schools. We have a USPTO certified clinic. The Southern University Law Center is the reigning USPTO champion with respect to patent prosecution and patent design. So we want to talk about that, the shout out. We have a technology and entrepreneurship legal clinic, as well as a disaster law clinic. We're the only law school in the country that has a disaster law clinic in the country. And we have been in Florida, Texas, New York, and other places helping people deal with disasters. And we have over 100 alums that are judges. So one of our alums filed a very famous case called Clarke versus Edwards, and eventually became Clarke versus Romer. And because of that lawsuit, Louisiana has the highest number of African-American judges per capita in the country. So again, the Southern University Law Center has been around for 73 years. Our first graduating class graduated 70 years ago. And we're very, very proud of the tradition. And we promote ourselves as the leading access and opportunity law school in the country. And I'm very, very proud to be here today to share this time with you.
Thank you, Chancellor Pierre. And I'm going to move on to questions now and actually combine a question in the chat with something we were planning to address already. The question in the chat is, what are the benefits of attending an HBCU law school versus a primarily white law school? What are the benefits? And that ties in with our first kind of topic that some say in light of desegregation, there's no longer any need for HBCUs or HBCU law schools. And I wanted each of you to comment on that, as well as address why should a student select to go to an HBCU? And our first respondent is Dean Keller.
Thanks, Dean Epps. So what I'll say about the question regarding why HBCUs are still necessary is that the legal profession continues to lack diversity. So Dean Hutchins has already mentioned that only about 5% of the lawyers in the United States are Black. That is relative to 12.3% of the population. So 12.3% of the US population in 2018 was Black. And that is not, to be clear, for want of students applying, right? So in 2019, there were 11.5% of the ABA applicants to ABA law schools were Black, 11.5%. So that's not too far off the 12.3% representation of Black folks in the population. But only 7.4% of admitted students were Black. And so we see that drop off from interest in law school to admission to law school. Here's the interesting part. Black students who are admitted to law school go to law school. 7.4% of the matriculants at ABA law schools in 2019 were Black. And Black students who go to law school graduate. 8.2% of the students who graduated from law school in 2019 were Black, but only 5.9% of lawyers in the United States in 2019 were Black. And so when you see that really drastic difference between the representation of Black people in the population and the representation of Black people in the legal profession, that, to my mind, makes clear why HBCU law schools are still very much needed. In terms of why attend an HBCU law school, there are many reasons to attend an HBCU law school, some of which my colleagues have already touched on in terms of our commitment to social justice, our commitment to access for folks underrepresented in the profession, and our commitment to affordability. So Florida A&M University College of Law is certainly very well priced. So those are some of the reasons that you might attend an HBCU, you might opt to attend an HBCU law school.
Thank you, Dean Keller. Dean Lewis.
Good morning again. Well, I think that saying that desegregation addresses the problem negates the thought that desegregation is not enough if you don't have an integration, just like diversity is not enough if you don't have inclusion. And so I think that what we see happening, like Dean Keller was saying about the legal profession, the lack of diversity, but even more so in the ranks, in the legal academy, in the ranks of law professors, is predominantly white. And there are some law schools that have no Black law professors at all. And I think it's critically important to have people who look like you and have your lived experience when you're trying to do something as difficult as going to law school. So I think HBCU law schools are still critically important because of that reason. Why go to an HBCU law school? I can think of three quick reasons. One is the graduation rate of Black and Brown students is just higher at HBCU law schools, and you want to graduate and pass the bar exam because of the debt that you're encumbering. Second, the social environment is more welcoming. You can have experiences at HBCU law schools. There's empathy that you can't find at PWI law schools. And lastly, because of the disparities in hiring, because if you look at the numbers at predominantly white law schools of their African-American graduates that are hired, even with the same credentials and the same standards, you will see that those numbers are a lot less. So that's why I think the HBCU law schools are still necessary, important, and will give you the great learning environment that you need. Thank you.
Thank you, Dean Lewis and Vice Chancellor Pierre.
Sure. Well, I'll give you a few quick reasons. The 6 HBCU law schools, although they constitute only 3% of ABA accredited law schools, graduate approximately 25% of African-American lawyers in this country every year. The second part is we are consistently rated among the most diverse law schools. What that means is this: when you go to Texas Southern, FAMU, North Carolina Central, Southern University Law Center, UDC, we have other race students, Hispanic, Latino, Asian, white, Middle Eastern, etc. All those, so it's like a rainbow effect, and that's what surprises most people. And then I think the third reason is, in addition to access and affordability, we believe that we have a transformational impact on our students, in that there are opportunities that are provided to them that would not be provided to them otherwise, because part of who we serve is we serve a lot of first-generation students who could not, in their own mind, believe that they could achieve accomplishments that they can as a lawyer and a graduate of a law school. And that's what we do. We provide what I call history-making transformational experiences to those law students.
Mm. Thank you, Chancellor Pierre. And next is Dean Holley-Walker.
This is a great question, and I think it's one that I'm surprised how often we're asked about the continued relevance of HBCUs, considering the statistics that Dean Pierre and Dean Keller and Dean Lewis just offered. In terms of, if you care about diversity and inclusion in the legal profession, then you must care about the HBCU law schools. We are an absolutely essential part of making sure that the legal profession has diverse lawyers. And we're talking not just about Black lawyers, but also about Latino lawyers, about Asian lawyers, about lawyers of color. So it is a critical part of what the legal profession must do, is to support and promote HBCU law schools because of outcomes, right? And I think the next thing for me is having attended a predominantly white law school and taught at 2 other predominantly white law schools. I think one of the things that I see in the atmosphere at Howard is really the ability to create community and create alumni network that really supports graduates for the rest of their careers, right? So when you get out of law school and you're looking for that first job, we have outstanding career outcomes, much better than what you would see for most Black students at predominantly white law schools. But then also their ability to access the Howard Law alumni network and to be able to call on judges, to call on partners at law firms, to call on general counsels who attended Howard Law and be able to say, I'm another Howard Law grad and I'm looking for an opportunity in this sector. And those are often ways that Black students feel left out at many other law schools, is they don't feel that they have full access to the alumni network. They don't feel that they have full attention and centering in the career services department. I even think about things like mental health and wellness, right? So for example, this summer after the George Floyd incident in the murders of Ahmaud Arbery and Breonna Taylor, the just hurt and pain in so many Black law students and that need to find community. And I think we know that in the HBCU space, students will have that community, right? The ability to support each other through what have been incredibly traumatic events. And I think the last thing I will say, and I think can't be emphasized enough, is affordability. Howard's the only private law school among the HBCU law schools. And even though we are not as affordable as our other HBCU counterparts, we're about half the tuition. So if you go down the street to, and I'm not picking on them in particular, but American or GW or Georgetown, our tuition is half the price of other private law schools in our region. And so that affordability piece, I think, is critical when Black students are choosing law schools. They have to think, and students in general, who should look at HBCUs as an affordable option.
Thank you, Dean Holley-Walker. And now Dean Hutchins.
Thank you. So I'm going to try not to be too repetitive. I agree with much of what has already been said. I just want to add a couple of things. So I think that the question, I want to push back a little on the premise of the question. I think in this country, we are frequently so quick to race to the after that we don't work on the through. And we are not yet, I think if there is nothing that we have learned in recent times, it is that we are not past the question of race in this country. And so while we have elected a Black president, while we have seen substantial gains for Black and brown Americans and Americans of all colors, that we have not yet wrestled with the fundamental paradigm that this country was founded on, a principle of inequity, not a principle of equity. And I think that until we truly wrestle with that reality, HBCUs in general and HBCU law schools in particular will remain relevant going forward. The only other thing that I would say is, I think that because of our history, HBCU law schools understand the law as a verb. We understand that the law must be placed into action. and that is the only way that it becomes transformative. And that's the reason why at so many of our schools, at my school in particular, UDC Law, it's the reason why we see such a focus and investment on practical training, on high quality clinics, on moving our students out into the practice in a way that can change the world. So yeah, the notion that HBCU law schools would not currently be relevant, I find astounding.
Thank you, Dean Hutchins. And last, Dean Bullock. Oh.
I would like to just add on to what Dean Hutchins just mentioned about the through. And talking about that, quoting from Charles Hamilton Houston, who was Howard's first dean. And it says, it says, without education, there is no hope for our people. And without hope, our future is lost. And education is the key. We have to educate. With education comes the necessary information by which others, those who are educated, can navigate through an environment which can frequently be a hostile or unwelcome environment. Education is what I would consider the bootstraps. You hear the adage about pulling yourself up by your bootstraps. Education is that bootstrap. HBCUs provide the tools or the education on how to tie those boots, the straps, so that the shoes can stay on the feet, so so that they are secure and they don't fall off. The person doesn't stumble. And that is by analogy saying that HBCUs oftentimes can provide the tools by which, through education, persons can learn how to navigate and utilize the law to better everyone in terms of becoming full citizens in America. One of the things that I see when it comes to legal education is oftentimes we do very well in teaching critical analysis, critical learning skills, and it's done in a very objective and neutral way. But what is not being taught when law is discussed and analyzing it in a very critical way is the context in which law arrives. Excuse me. And as was mentioned earlier about the lived experience, Black lawyers, we have lived experiences and others can learn from those, from the vantage point of those lived experiences. It's not a case, it's a life, and it's a lifetime of hurts, of slights, of microaggressions, injustices, and inequities. So an HBCU can provide a safe environment by which the law can be learned fully with critical analysis, as well as learning the context, the motivations behind how it gets to this situation. One of the things that has already been brought out in the introductions of everyone about our law schools is that there are various motivations about why our schools came into existence. Those same motivations about why the schools came into existence are still here. It's about values. You can't legislate morality, and and as a result, the important thing is to educate people so that those values over time can change. And once those values change, then when we can discuss that in the law, in teaching law, about the context and how we can utilize the tools to ensure that everyone is able to utilize the law as Thurgood Marshall, as Charles Hamilton Houston, in making sure that everyone is able to exercise their rights here in the country.
Thank you, Dean Bullock. And a quick question, I think that was dropped into the chat, and we can probably do this with just a show of hands. Either your actual hand usually works easier for me than the one that you can use on Zoom. Which of the law schools accepts the GRE for admissions? I see no hands. Okay. Is there any benefit that you see to a student in taking the GRE?
Yes, so while we don't yet, we're actually going through what's called a validity study, ETS. And before law school can accept the GRE as part of its admissions, they have to go through a validity study. So we are in the process of going through that validity study, and there is an advantage to taking the GRE because, for example, we have a dual degree programs. We have a JD MPA program, for example, dual degree, and GRE and GMAT scores are very, very good. And they're also a good prep for the LSAT in many ways. So I do see some benefits with the GRE, and we are having that discussion with ETS to go to the validity study.
I just wanted to add one thing onto that briefly. I do think that as leaders in legal education, it is incumbent upon us to be thinking critically about what the point of certain practices or policies is, and thinking critically about whether those things are unnecessary barriers to a legal education. And so I think what many studies will tell us is that the 1L GPA and not the LSAT or the entering GPA that the 1L GPA is the best indicator of how students are going to do on the bar. And so while we do not currently at UDC accept the GRE as an admissions metric, I do think that it's something that we should all collectively, not just the HBCU law schools, but all law schools, should be thinking very, very, very intentionally about whether the world we have adopted is the world we want to continue to live in.
Well, this has been an interesting discussion, and our time is moving on, and I want to make sure that all of you have an opportunity to respond to this very important question. We have 600 viewers of this conference, this presentation. So what are the ways that those viewing can help you in your efforts of diversifying legal education, of doing whatever your specific school mission is? What is there that they can do to help and support you in that? And I will start with, let's see, Brownie Lewis. Dean Lewis, I'm sorry.
That's okay.
I know all of this, I want to use first names.
Well, I think it's critically important to support HBCUs financially. And that's one thing. Another thing is with the ABA and accreditation, that there are certain policies that adversely impacts HBCUs that we as a unit come and speak out against, but would be more impactful if we have support from other persons. Like, for example, Standard 316 about the bar patches. And there are just some other things that, and you know, using the LSAT and the different indicators. So just giving support. And the last thing I would say is joining the conversation and not leading the conversation when it comes to issues about the law and race and the lack of diversity in the profession. Thank you.
Dean, thank you, Dean Lewis. Dean Hutchins.
Thank you very much. So I agree with everything that Dean Lewis said, and I would want to add, I think, collaborate, right? So if there are conferences that you are hosting that we could perhaps host together, let's do that. If there are speakers that you can afford to bring in that we cannot afford to bring in, let's think about partnerships there. And then one that is of particular interest to me is, I think that one of the things that you will see is that at HBCU law schools, we believe in the whole student, and we tend to take chances on whole students, right? We are not guided exclusively by numbers, but what you will frequently see is that after we have accepted those students, after we have accepted some students that we believe firmly in, that we believe can succeed, once they have demonstrated their worth in our institutions, they are poached by higher ranked, better resourced institutions in a way that is profoundly unhelpful to us. So I would encourage you not to do that.
Interesting. Thank you. Dean Hutchins, Dean Bullock.
I would say that to work with us in mentoring our students, hiring our students, exposing them to a world that many of them may not have had any contact with or seen. What I see with many of the law students in an HBCU are coming in with a narrow view of the world based upon what they have seen, what they're actually around, or maybe what's seen on TV. And we all know that TV is not real life. But what students need is an opportunity to acclimate, an opportunity to see how the real world not only is functioning, but thinking. And it would help to demystify so much of what is going on. And as we all know, law is not just a siloed profession. It's law and business, law and technology, law and everything else. And without that critical understanding of how the world works and having exposure to individuals that they can talk to, ask questions, and to see things, then it would be difficult for our students, even if they passed a bar, to be successful as lawyers or as successful as they would like to be. So having that exposure to others, to law firms and to businesses and to companies and organizations would be very helpful.
Dean Bullock, thank you. And Dean Keller.
Yeah, I'm gonna agree with what my colleagues have said and underscore the importance of contributing financially to the success of HBCUs, because we've all talked about affordability, right? And there are costs, obviously, to educating lawyers of color. And so those costs, we have to meet those costs while also managing affordability for our students. And so I want to really emphasize that piece of it. And the other piece of it is in part related to what Dean Bullock just said, which is about providing opportunities for our students. Those are both in terms of externships and internships and hiring our graduates. All of that will strengthen our colleges and therefore add to the project of diversifying the profession.
Thank you, Dean Keller. Chancellor Pierre.
I'm going to get on my soapbox. ABA Standard 316 as it currently exists is a travesty. And we have, as a collective group, said that for the last 10 years and will continue to say it. And I want my fellow leaders in legal education to deal with it as it is. That's an example of implicit bias and racism. I'm going to put it as plain as possible. The U.S. News World Report, being slaves to that U.S. News and World Report ranking, is also another negative. I know we're going to have people from U.S. News and World Report, but I have never responded to that, and I think we need to figure out a different way of how we do that. The next thing is collaboration. We have had the opportunities to collaborate, and I'm going to say something that maybe nobody else wants to say. I believe, at least at Southern University Law Center, and I believe at the other HBCs, we have a very robust academic support program. And if you feel that there is a student who is a student of color that because you don't have that robust program could be a good candidate, but you're a little shy on admitting them, have them send me an email, jpierre@sulc.edu. Dean, you know I will recruit anywhere, any place, in and around. I've been following Dean Epps everywhere she goes. She walks into my territories where I recruit, and we turn those people. Those are diamonds. Those are diamonds in the rough. We turn those people into great lawyers and great leaders, great corporate lawyers, great leaders, and that's what we want to do. Again, we want to be a transformational institution for those folks. I'm always willing to collaborate. Pierre at sulc.edu every day.
And I don't want to see you out in front of my building recruiting Chancellor Pierre.
I've already been there. You just didn't notice me.
Dean Holley-Walker.
So I would say, you know, I was to see the CEO of Wells Fargo on TV saying that the reason that there were not enough Black people working at Wells Fargo is because there wasn't enough Black talent was outrageous to me. I would say that for any legal employer currently on this call, if you are committed to diversity inside of your corporation, inside of your law firm, you can't be committed to diversity unless you are in partnership with an HBCU. Howard has just tremendous career services placement opportunities, but not all of our HBCUs do. And many of it is because employers just don't partner with HBCU law schools. But I think in your hiring committees, you must, as law firms, say, if we are hiring from, and I'm now going to say something controversial, but I think I have to. I've been on a hiring committee in which we recruited from South Texas, but we wouldn't recruit from Texas Southern University. If you find yourself in practices like that, please stop. And begin to reevaluate the way that you think of HBCUs as your talent pipeline. We are your talent pipeline. If you want diverse employees, you must recruit from HBCUs. I would also say commit to pipeline projects. We run a pre-law scholars program. We are looking for a corporate sponsor for that pre-law scholars program. And we really need corporations and law firms to commit to working with middle schools, working with high schools, working with HBCU undergrads. Chancellor Pierre was recruiting at Jackson State University with their pre-law program. I just went and recruited at Jackson State in their pre-law program. Partner with us to work with HBCU undergrads. You know, so again, if you're deeply committed to diversity, please make sure that you are funding programs at HBCUs to expand the pipeline. That is your most effective way to increase diversity in your workplace if you are a legal employer.
Okay. Well, we have been given the sign that there are a little bit less than 10 minutes remaining, and I want to partially address a number of questions in the chat that have been about admissions and what the admission approaches are and how aggressive you are in recruiting. And I already know about Chancellor Pierre, so I'm gonna leave him out of this, not let him start off. How about we will start with Dean Lewis. And it's gotta be quick. We only have 7 minutes.
Thank you. We recruit aggressively using technology. We have a virtual justice program where we teach 2 virtual justice pipeline program. And through that program, we recruit undergraduates, we teach undergraduates, and we have 3+3 agreements with HBCUs.
Okay, very good. Dean Bullock.
Well, as was mentioned earlier, we also look at the individual holistically. So our application process is one where we review all the characteristics of the individual. We're also looking at partnering with some undergraduate institutions for some 3+3 programs as well.
And Dean Keller.
Yes, so my admissions team attends, so for example, the pre-law event, the HBCU pre-law event that took place earlier this month. Generally, in normal times, we travel pretty extensively to HBCU undergrads and other undergrads where we recruit students. Of course, all of that is happening this year virtually. And so this year has been a little bit different that way. But we just had an open house for students. We hosted 120 students at a virtual open house just earlier this week. And so we are up and running recruiting for fall of 2021.
Dean Hutchins.
Yeah, thank you. So I'll be very fast. At UDC, we do believe in the whole person. And as I said before, we believe in the law as transformation. So we have something called an injustice essay that is a part of our application. We are looking for students who have seen injustice and want to speak out against injustice. So we are looking for students who want to put their law degrees to work.
And Dean Holley-Walker.
We recruit around the country. We're a national law school. We have a large number of students from California, from Atlanta, of course, from the DMV area, from New York. So if you're a student from around the country, do not think that you are limited because you're not from the DMV area. We are truly a national law school. We have a highly competitive admissions process, and we've had record applications over the last 4 years. So we encourage you to be in contact with us, talk to us about our standards for admission. And I echo Dean Hutchins, one of the most important parts of your admission application to Howard is explaining your commitment to racial justice. That's a key part of our application. And even if you have a sky-high LSAT score, if your essay on your commitment to social and racial justice is not strong, you will not be admitted. So I really encourage you to focus on that part of your admissions application. And we welcome your applications and welcome talking to you. We are bringing in larger and larger classes by just a little bit, by about 5% every year. And so we really encourage you to apply to Howard University School of Law.
Chancellor Pierre.
Well, we have students from 35 different states. So we're not exactly as national as Howard, but we're getting there. But here's the most important thing. We have students from Alaska, Idaho, Iowa, places that don't have large percentage of Black students, but it doesn't matter to us because we are really, again, a school of access and opportunity. And to be honest, one thing I will say, 80% or more of our students actually have undergraduate backgrounds from other schools other than HBCUs. We're a member of Hbcu, Hispanic Association of Colleges and Universities, and we have lots of students from what we would call traditional or predominantly white institutions at the University of Law Center. So we're diverse in so many different ways. You know, you really can't imagine. You have to come see the place.
Okay. Well, thank you all for your participation. It was very informative, and I know that you are each one open to getting follow-up questions, should there be any from those out there listening to us, 610 out there listening to us. I could not get to all the questions in the chat, and really I'm just learning the Zoom thing. So it's amazing I even noticed those questions, put them out there for you. But thank you for your response and your participation. I look forward to seeing you around, not in front of my building recruiting students, Chancellor Pierre, but if you come to town, please stop by UNT Dallas College of Law. Thank you. Now, at this point, we will have a 10-minute break that will be followed by the Bracewell LLP Distinguished Lecture in Racial and Social Justice keynote speaker, David Wilkins, and that will begin at 12:10. Thank you all.